It's the second half of Freedom Talk for Wednesday, the 6th of March. And we've got in our studios for the second half the Attorney General, the Honorable Jason Hamilton. Good night to you, Attorney General.
Good night to you, Mr. Edinborough, and tonight, good night to your listeners out there on the radio and via the World Wide Web.
All right. Attorney General, who is Jason Hamilton?
Well, I'm originally from St. Johnson's Village. I've lived in St. Kitts my entire life, save and except for when I went off to study. I went to University of the West Indies in Cave Hill, where I obtained a Bachelor's of Law. And then I went to the Norman Manley Law School, where I obtained my Certificate of Legal Education, and I came back in 2001. I opened a practice with my father. Well, my father had a practice and I joined him, more accurately. And I have been practicing now for 11 years and some change, until my appointment recently as the Attorney General.
All right. Wow. And so, eminently qualified, Kittitian, ready to serve. All right. Now, Jason, right away we are going to get into the appointment, because we know that for the first time in our history in St. Kitts and Nevis, the appointment of an Attorney General was challenged in court.
That is correct.
And so we'll spend a little time on that, because I'm a little bit confused. Well, maybe a lot confused as a result of the judgment in relation to your appointment as the Attorney General. But before we get into that, just tell the people, what is the function of the office of the Attorney General?
Well, essentially, the office of the Attorney General is the principal legal advisor to the government, as stated in the Constitution in Section 64. Essentially, he gives advice to the government and varying government departments, whether it be in civil law with contracts or transfer of property, matters of that sort. The Attorney General, and specifically the Constitution as well, that is the principal role of the Attorney General. Of course, the Attorney General has the Attorney General Chambers, which has Crown Counsel in it, Solicitor General, Crown Counsel, Senior Crown Counsel, that all aid in that advice to the government and the government's legal work on the civil side.
Okay. Now, we have a situation where you were appointed twice in the same job.
Correct.
And so let me ask this question first of all. Were you appointed on the different sections of the Constitution in any of these two appointments?
Well, I was appointed under the same section in each instance. What happened was there was a challenge, as you know, in court, and the court ruled that the procedure in the appointment under Section 26(2) was not followed correctly. Mm-hmm. That wasn't what was originally sought. In fact, originally the originating motion that went to court was seeking 12 different headings of relief, including that the Attorney General had to be a public officer, appointed under the Constitution. Subsequently, that dropped to 7 heads of relief, and then that dropped ultimately to 3, and the court ruled in favor of the interpretation given by the claimants. That matter is now subject to appeal. There are certain aspects of it that we feel from our side that needs to be challenged. I won't want to get into specifics on that tonight, but basically the section under which I was appointed originally had been the section that was used previously in the appointment of other attorneys general. And
it is the same section under which you are presently appointed.
It's the same section under which I was presently appointed. The only difference was the order of appointment not the order of appointment in terms of senator and attorney general, the order of appointment in terms of how many senators were present before the third senator could come into play. But originally, as I said, the claimant's case was that you couldn't be an attorney general senator. You had to have been appointed, and I don't want to misquote it, but that a declaration that the fourth defendant is not a minister under Section 64 of the Constitution and can only be appointed as a public office Attorney General.
Which is under Section 80 of the Constitution, where the public officer is
it deals with that as well, but Section 64(2) says that the office of Attorney General can either be a public office or an office of a minister.
All right. So this brings me to the question that I wish to ask, in terms of the ways in which the Constitution contemplates an appointment of an Attorney General. So he can be done in how many ways, and what are the ways?
As far as I know, it can be done in 3 ways. An elected representative who is qualified to be a barrister, well, an attorney at law, could be appointed Attorney General, as the Honorable Patrice Nisbet was. And you can also be appointed if it is a public office. And the third way would be if you are a senator who is qualified to be Attorney General, you can be appointed in that way as well. So as far as I'm aware.
And all of those ways are constitutional.
All of those ways are constitutional.
Right. Now, there is another issue surrounding your appointment as Attorney General as a result of the judgment, which baffles me as a citizen.
Which is that?
It has to do with the fact that someone who was serving in a different capacity had to resign or be terminated. So let me see if I can put it properly. Here you have 2 citizens of the same country. One citizen holds a particular job, and another citizen is to be appointed not in that job, but another job. And the judgment seemed to be saying that for you, this citizen who is going to be appointed in the other job, this other citizen who is now employed, who is not going to function in that job, must first resign or be terminated. I have a difficulty understanding what that part of the judgment is saying.
Well, our position from the government side was always that the purposive approach of interpretation is to be applied to the Constitution. Otherwise, you would be seeming to be making a mockery of it. So where you have a situation where the status quo that existed on Thursday morning was essentially returned to normal on Friday morning, where you had to go through, I don't want to use the word improperly, but let's say rigmarole of disappointing, quote unquote, someone and then reappointing them the next day after having appointed an Attorney General. We never thought that that was that could be the purpose that the framers of the Constitution intended. The section speaks to 3 senators sitting on the government side, if one of those senators is the Attorney General, and so it had been done in the past. It had never been challenged before as to how the procedure ought to be followed. This was the first time that happened, and so the government felt that that was the proper procedure to follow, and made the appointments accordingly.
I want to make reference to Section 26(2) of the Constitution, Mr. Attorney General. And that section is of 2 paragraphs.
Correct.
The first one says, the number of senators shall be 3 or such greater number, not exceeding 2/3 of the number of representatives as may be prescribed by the Parliament, provided that at any time when a person who is a senator holds the office of Attorney General, the number of senators shall be increased by 1. When, as a layman, when I read that, I interpreted that to mean that there's always a vacancy in the Senate, 1 above whatever is the number allowed for a person who is holding the office of Attorney General, as long as it does not exceed 2/3 of the elected members. I mean, that's how I read it as a layman. That's how what I thought it meant. But based on what the judgment is saying, that is not so. But in looking at the judgment, I was trying to find some explanation as to what this final paragraph means, provided that at any time when a person who is a senator holds the office of Attorney General, the number of senators shall be increased by 1. I didn't see any explanation with respect to that in the judgment. That leaves me a little bit confused. So I would like you to, take a little time and try to explain from your viewpoint what that section means.
Well, again, as I indicated earlier, there are 3 ways, as far as I know, that the Attorney General can be appointed. Now, the Constitution always envisages that where a person is an Attorney General, whether by way of public office appointment or by way of a senatorial appointment, that person sits in the House. So I don't know that if it's correct to say there's an extra position, but the Constitution has it that the Attorney General sits in the House. Now, it can be argued then that if that is the position, then the Attorney General would be, if he's appointed as a senator, what order of the appointment might not be that relevant, and that was our view on it and the interpretation of it. But it indicates that it shall be increased by 1. So the government is allotted 2 senators, and where one of those senators is the Attorney General, that number increases by 1. That means the government has 3 senators. That was using your description of it, the layman's approach to how that should be interpreted, and that was the legal approach in terms of the interpretation of the section. Even though that increase occurs, the Constitution has other provisions that says in calculating or tabulating the number of senators, where the Attorney General is that 3rd senator on the government side, that does not factor into the equation. That was one of the things that originally was pleaded in the documents by the other side, where they were saying, well, if you can go up to 4, you've increased the senators, and we're entitled to another senator as well. The Constitution clearly says that.
And the Constitution says that when that is so, that senator is an Attorney General, it should not be a part of the equation.
That's correct.
Well, while you're looking for that, we have been talking about interpretation all night. And I want to ask, when it comes to matters, constitutional matters, is it a given in terms of what comes out of a hearing? Or, well, what is it about? Is it fact or interpretation? And if you could explain the difference in those two things.
Well, to put it simply, the reason that there is litigation in most cases on interpretation is because different persons have different interpretations of a particular section. The Constitution is a live document that is often challenged in this jurisdiction and in many other jurisdictions. I would dare to say maybe all jurisdictions, where people challenge one person's interpretation or application of the Constitution. That's not abnormal. And in a democracy, that is something that should be welcomed, because it gives clarity as you go along as to how the Constitution should be interpreted and read. In the U.S. recently, there've been some discussion on Obamacare, whether that was constitutional in relation to the states passing legislation and that kind of thing. So it's something that normally happens.
All right. Now, so when it comes to the matter of the Constitution, it is just how a presiding judge or judges sees it.
Well, in the particular case, and that's why there are courts that you can appeal to, because courts that you can appeal to may have a different interpretation of the same section. And so that's the process will take its full course, and we'll wait for the outcome of that.
And there is somewhat of an outcry, which I believe is really malicious, for want of a better term, about an appeal, and persons are giving the impression that citizens are being burdened with unnecessary cost in appealing the matter. And I want to ask you, with respect to a particular matter recently that came against this same sitting government, and it had to do with the former Attorney General, well, not the one before you, the Honorable Patrice Nisbet, but Dr. Merchant.
Okay.
and there was a judge, a presiding judge,
He was found in contempt.
he was found to be in contempt.
Correct.
And, well, what was the final outcome of that matter?
I don't know the whole final outcome, but I know in relation to the contempt charge that was dismissed as against Dr. Merchant. And that was only done on appeal. At first instance, there were persons making noise. And, you know, that's why there's an appeal court, because the judicial system recognizes that sometimes 3 heads are better than 1. And so we go through that process, and we'll wait the determination of the court in that respect, and we'll be guided by it if it doesn't go in our favor.
So in other words, in the first instance, when Dr. Merchant was taken to the court, the judge said, well, yeah, I think you're in contempt of court.
Correct.
And it was appealed, and the appeal judges said, no way, not on this matter.
Correct as well.
And so, with respect to this judgment, something as important as the Constitution, and I'm going to ask you now, do you really believe that if the judgment had come the other way, that the other side would not have appealed this matter?
Well, I certainly believe that. The other side, and I use that in inverted commas.
Mm-hmm. Well, in this
right.
case,
what happens a lot of times, persons get upset when a judgment doesn't go in their favor. Mm-hmm. And I've heard persons who are in opposition or support the opposition party say things in relation to, that's why we shouldn't have a Caribbean Court of Justice, because regional judges don't know what they're doing. If you respect the court, you respect the court's decision. You understand there's a process, there's a court of first instance, and there's an appeal court. If it goes in your favor, it does. If it doesn't, well, you know. But which is why the government made the necessary, you could call it procedural changes in the interim, even though the decision is being appealed, because the business of the government still has to go on. And we'd want to make sure that in the period in between that we are doing the right thing, as according to the judgment that has already been pronounced. And it gives clarity in the future going forward that, you know, definitively, well, this is the order that you have to follow, then that, so be it. But we want to let the process take its course. Yes, sometimes the cost of litigation is expensive, but in constitutional matters, I don't know that you can be, you know, watching the purse like that, because these are matters of state that need to be clarified, and need to be clarified as far as you can go in terms of the judicial system.
And would speak to future generations.
It would. I mean, a decision coming from the Court of Appeal on it is definitive. It's not just definitive for us necessarily. It's definitive within the OACS, in as much as there's been no case specifically on this point. I don't know if there are other constitutions that have similar provision, but it can serve to guide them as well, coming from the regional court.
All right. Now, one of the things that I've heard been bandied about in relation to this particular judgment is the notion that some way, because the case came against the government, that there was a flagrant disregard of the Constitution in your appointment. I do believe, however, that the judgment spoke to that in the area where it said that no cost was awarded. So if you can speak to that particular.
Well, the judge did rule ultimately that he thought the matter was of such national importance regarding the Constitution that each party should bear their own costs. I don't think it was a flagrant disregard of the Constitution in terms of how my appointment was made initially. That had been the procedure that had been followed previously, and I would imagine all parties assumed, because the two claimants in the matter were present in the House when Dr. Merchant was appointed under the same section in the same matter, and there was no resignation of anyone and there was no reappointment of anyone, and both were present. So
and did not challenge it.
Did not challenge it. So it's either a matter that they have recently come to discovery that that interpretation is wrong, or they knew it all along and said nothing about it. I don't know which it is. I wouldn't want to speculate on it, but it's not that my appointment initially was something that had never been done before. There was no reason for the government to presume in those circumstances then that it was wrong.
All right. Well, you know, very interesting, because, well, I can't put my finger on it directly, but I look for it because I know that somewhere in the judgment he indicated that one of the reasons why no cost is awarded. Yes, he said that it was a matter of national importance, but he did go on to say that use words to the effect that it was not something that was...
It wasn't frivolous.
Frivolous.
That's what he said. It wasn't a frivolous matter that was brought before the court, and so he didn't award cost.
All right. All right. Now, getting up to 9 o'clock, before we go to a break, there is another question that has been bandied about in the airwaves here as well, and it has to do with a letter that was sent to the Governor General. I think it was yesterday. The two members that previously sat on the government benches, the Honorable Sam Conda and the Honorable Dr. Timothy Harris, I think, wrote to the Governor General saying that they were crossing the floor.
But
I'm saying that that's what
I've been hearing that all day. I've had a chance to look at the letter myself. They didn't say in the letter that they were crossing the floor.
No.
They indicated in the letter that they were voting with the opposition. Now, whether they will do that vote while sitting on the government side of the benches or whether they'll do that vote on the opposition side of the benches remain to be seen. But certainly they have indicated that their vote will now be sided with the government, with the opposition. So in that respect, their vote has crossed the floor and has sided with the opposition in that respect. So they're now voting with the opposition.
Well, I'm a little bit puzzled because, I mean, it would not be one vote. I mean, suppose you are asked to vote on 3 different matters. What are you saying, that you, regardless of what the matter is, you're voting? Because I'm a little bit confused. I thought they had said they crossed the floor, but if they're just saying that their vote
well,
is...
they didn't use that phrase.
Yeah.
Their vote, one can say their vote has crossed the floor on the matter of the no confidence motion. So they're voting with the opposition side.
Is it just for one matter they indicated?
Well, they also indicated in the letter that they don't think any other matter should be heard in the Parliament before the vote of no confidence. I don't know if you're on the opposition side that you can make that determination, but
all right. So
the government's position on that is that the budget will be debated first.
So it is in relation to the vote of no confidence that they wrote that letter?
I would want to presume so.
Okay, based on your reading of it. All right. Now, there's also in the airwaves the talk about a situation in the Solomon Island where the sitting Prime Minister, I guess, was avoiding the calling for an assembly to debate a motion of no confidence, and some indications from Mr. Dwyer Stefan that it is similar to our situation. I've done some research on that myself, and I have seen that there are some marked differences in the Constitution there, and the way the Prime Minister is appointed, and the rights of the Governor General in terms of his authority. I've seen those differences, and so when we come back, we're going to go to our sponsors. When we come back, I would like us to look at those 2 matters: the ramifications of the letter that has been sent to the Governor General here, and the situation that occurred in the Solomon Islands, and how there is what similarities and differences there are in relation to our situation and our system. So we go to our sponsors, and when we come back, we shall look. Well, welcome back to Freedom Talk. Before we get into the 2 matters that we're going to deal with in this section, nearly forgot one of the most puzzling part of that judgment to me, and it is, well, what happens as a result of Senator Carty having to resign. The question is, can that resignation, as I would see it, as an interruption in his service, as prescribed by the court, can that have ramification in terms of his pension, things like that? That is one of the things that's quite puzzling to me with respect to the judgment.
I don't think it would. I can't say definitively at this point, but I know in relation to pension for representatives, members of the National Assembly, there's a factor as to the total time served as a member. So I don't think that it should.
Okay. Well, just thought that I would ask that because I am concerned about that. Going forward, it does not have anything to do with who it is now. It has to do with whomever it is. All right. So let's get back to the letter that was sent in. Now, there are some persons who are of the view that as a result of this letter being sent to the Governor General, that, and the Mr. Astafan also said that, and I heard him saying that the case in the Solomon Island mean that because the Governor General had summoned a meeting of Parliament there, that the same thing can be done in our system here. What are the differences in terms of that within the Constitution, and what are the similarities?
Well, if we're talking about the same case, as you know, Mr. Edinborough, each case is sometimes determined on its peculiar circumstances. In that case, if we're speaking about the Healy versus Governor General of the Solomon Islands, assuming that that's the same case, in that case, there were some marked differences between the Constitution of the Solomon Islands and the constitutions elsewhere. In fact, one of the judges started his judgment by saying the Constitution of the Solomon Islands is unique. One of the peculiar things that doesn't exist in our Constitution is that the Prime Minister is not appointed on advice given to the Governor General as the person likely to command the support of the majority in the House. After an election, the Prime Minister is actually voted on by the members of the House. In that case, there was 24-23 difference between the elected members as to who would be Prime Minister. That was in about, say, August 1993, and then there was no sitting of the House until maybe about January 94. What happened in the intervening period, the Prime Minister became uncertain as to his majority. He had a one-seat majority. And then, subsequent to that, persons defected. And there were indications that there would be a vote of no confidence filed. It wasn't actually filed. The second difference in the Constitution of the Solomon Islands that was reported in the case is that the Governor General in that case is the person who is entitled to summon the House to a meeting, to the National Assembly to a meeting. What happened, the Prime Minister, because of the impasse, had indicated to the Governor General that he didn't have the support of the majority. The Governor General intimated to him that he should either resign or call the House and see what happens with the no confidence. House was never called. In fact, during the intervening period as well, they did some appropriations of funds to cover the budget. And there was a case that went to the Court of Appeal that determined that that was unconstitutional. So you had a real state of impasse in that case. Ultimately, the Governor General purported under the Constitution to summon the House and to dismiss the Prime Minister. Now, the judgment and both the Court of Appeal and the court that it was referred back to at first instance indicated clearly that they're not making any determination on the issue of whether the Governor General has the power outside of the Constitution to fire the Prime Minister, quote unquote, fire. They determined that the Governor General did have the authority to summon the House in that case because the Constitution gave him that power, and in summoning the House in the way that he did, and the Prime Minister refusing to go to the House, even though it was summoned, that the Prime Minister acted improperly, and so the court ruled in favor of the Governor General on that point. So I don't know that that has any marked instances for us. I know that the Constitution outside of the occasion after an election doesn't give the Governor General the power to dismiss the Prime Minister. So I don't know what the implications of that are.
Only in the case where motion of no confidence
only in the
is
case,
debated
in the case of a motion of no confidence where that is debated and it is passed. I think the case, one of the questions in the case on appeal was whether it is lawful for the leader of the opposition to advise the Governor General to cause the Prime Minister to step down or otherwise remove him from office outside the floor of Parliament. the leader of the opposition may lawfully express such an opinion, but he can give no advice within the meaning of Section 31(1) of their Constitution.
So, in other words, even that constitution that gives the Governor General certain powers is saying that the leader of the opposition cannot advise the Governor General within the ambit
of that section. So,
that section.
I don't know if the letter purported to be advice. It didn't speak to advising, so I don't know what the purport of it is at this point as I sit here. Aside to say that two members who were formerly part of the Labour Party government have indicated that they will be voting with the opposition on a particular piece of legislation. Well, a motion, forgive me.
An motion. Well, let me, because you made some interesting observation. One is that after an election, the prime ministership is voted upon within the parliament by the elected representative.
Right. That is in the case of the Solomon Islands.
Yeah, that is how it is done in the Solomon Islands,
Right, so
which is not the case in St. Kitts and Nevis.
No, not at all. Not at all.
Is that the leader of the party, that's the way it's normally done.
The leader of the party,
Will go to the Governor General, and then based on that interaction, the Governor General will make an appointment in
Correct.
his own deliberate judgment.
Well,
yeah, but that's what the Constitution says.
right. Well, it's different. Their position is markedly different from ours in that respect.
Having regards for that as well, when you look at both instances, then it is appearing to me that in one instance, an absolute majority is necessary for government to be formed, for prime minister to be named. Sorry.
In the Solomon Islands?
Yes, in the Solomon Islands.
That's the word of the judgment, actually.
Yeah,
absolute majority.
Absolute majority is necessary for a prime minister to be named.
Correct.
In our case, is that so? Based on history, and what is presently.
No. It's the person who, like I said, likely to command the support of the majority in the House. That is the Governor General acting in his, once he makes that determination, he makes an appointment. It's I wouldn't say it's scientific, as in he knows exactly you have 8 people on your side or 4 people on your side, based on the party and the leadership of the party. The leader of the party comes and says, I have 4 people on my side with me, make 5. That has happened before, where the Governor General makes an appointment.
Made an appointment in St. Kitts in 1993. Correct. Without an absolute majority.
Correct.
All right. Now, there was also some talk with respect to you being in the National Assembly and whether or not you could have voted once the appointment is made, whether or not you could have voted on a matter that was being discussed before you were appointed. Would you like to say anything in relation to that?
Well, once you're appointed, you have all the powers and privileges of a member of the National Assembly. So I went to the House with that on that basis. That was a part of the case that was subsequently withdrawn as well.
Mm-hmm.
And the taking of the oath, the standing orders speak to that the oath is taken immediately after prayers. That's specific in the standing orders.
Mm-hmm.
The oath of office is taken immediately after prayers. So this, the discussion on whether there was an amendment to it or not, the House started, the House had prayers, and I took the oath immediately after prayers. Once that occurred, I had all the rights and privileges as a member of the House.
But in essence,
one of those rights being to vote.
Yes, and they withdrew that part of the original claim.
That part of the original claim that they were seeking in relation to those things was withdrawn. That's correct. Yeah, that's why I said they started off with 12 grounds of relief, that dropped to 7, dropped to 3.
All right. Now, the big question is, who determines what? Is there anything in our Constitution that determines whether and how things take precedence in terms of what is on the agenda of Parliament? The question is, within our constitution, because I mean,
Well,
and
no.
any laws,
Places like
'cause
Antigua, their constitution, I think, specifies how soon a vote on no confidence is to be heard after it's tabled. Our constitution doesn't have any provision like that, so it's governed by convention, and convention dictates that a vote on no confidence is heard as expeditiously as possible,
that's
depending on the exigencies of the government agenda.
Now, the reason why I'm asking that, you see, because the impression that one would get is that there is no constitution anywhere in the world which speaks to how a motion of no confidence is dealt with once it is tabled. And my question would be, because you have indicated one such...
I could be wrong with that. But
yeah, but...
there are territories that have specific timelines.
Specific
my research
timelines.
indicated that.
Yes, but I'm aware too. I wasn't sure Antigua, but I'm aware in some of the Dutch countries in particular that the Constitution speaks clearly as to how these matters is to be dealt with.
The procedure of how these matters should be dealt with.
The procedure of how these matters...
Because we get into a lot of procedural things these days.
Is to be dealt with. And so, the question I want to ask, and it beats me as to why up until this moment neither the People's Action Movement government or the Labour government has sought constitutional reform of any sort. So the question is, if there is weakness as persons perceive it in dealing with these matters, shouldn't we as a society be concerned in terms of making changes to our constitution that these things are dealt with and properly spelled out within?
Well, I think I said earlier in the program that the constitution is, I don't want to offend anyone when I say, but it's a living document. It's something that is supposed to evolve as a country evolves, and changes are supposed to be made where you feel that areas are not as tight as they should be or something needs to be clarified. One example would be the indication on the last occasion at the House with the Senator's bill. Persons ask, how could I have voted on the Senator's bill? My simple answer to that is that the Constitution made provisions for the number of senators to be increased. It was a constitutional requirement that was there since the Constitution was formed. So in my mind, there was no question as to the legality of making voting on the bill. So perhaps members who had been there for some time, if they saw that that was a problem, ought to have sought to have that section changed. There's been some question now about dilution of votes and that kind of thing. They could have made constitutional amendments to stop that. They could have created a bicameral house. None of that was done. But be that as it may, we need to seriously start looking at the Constitution and to bring it up to date. It would be 30 years old this year. So perhaps it's time to start looking to make some changes that the society expresses that they would like to see in the Constitution.
All right. Now, telephone numbers for anyone who wishes to join the discussion. It's 465-0546, 465-6474. The overseas line, it's 305-515-3099. And you're listening to Freedom Talk, and we have in our studios tonight the Attorney General. Well, the first call comes in. Good night, caller. You're on.
Good evening, Mr. Host.
Good evening to you, sir.
When you have a general election in a country, who forms the government after the general election?
Well, do you have another question that you would like to ask? The Attorney General is going to the section.
I'm trying to have a little discussion with you.
With me? Well, I have an in-house guest. And
I know that, but you also go to the in-house guest.
Okay.
Because the in-house guest that you introduce is the Attorney General.
So you want my opinion on who forms the government?
But let me fix it since you don't want to rap tonight. Because
No. I, if you want my opinion, I will give my opinion. But
no, not opinion.
Oh, who forms the government?
Constitution. Who forms the government?
The person who is in the Governor's General deliberate judgment commands the majority of elected members.
Of elected members.
Yes.
Presently, right now, who have the most elected members in the House of Parliament?
I don't know. I don't understand. Wait. I don't. You say who? So I don't understand the who. That's what I don't understand.
Opposition bench has the most elected members presently in Parliament.
Well, I can't say that. Up to the last time.
You can't say that.
Up to the last time.
The former deputy prime minister.
Are you wishing to dialogue, or are you wishing to make a point? Because I'll let you make your point if that's what you wish.
We don't do one thing, but rather than wasting time, we just get straight to the point.
Well, I'm telling you that based on the last sitting that I know, the majority of elected members sat on the government benches. There is videotape to show that.
Yeah, but presently right now, the Prime Minister is the minority.
Okay.
How could he appoint Attorney General when he does not have the majority of the vote in the House? This is what got me confused, just like how the judgment got you confused.
All right, well, I will let the legal mind answer that question.
Well,
I will listen after you then.
Yes.
After the appointment, after an election, and well, let me quote from the section actually. Once.
Well, hold that answer. Let's take this call and then we'll answer the two questions. Right. Good evening, caller.
Good evening, Mr. Edinborough, and
Yes.
also your co-host.
Co-host, guess.
Well, maybe maybe you
trying to
speak
give
so
me
well
another
that they're trying to give you another job.
General Mr. Hamilton.
Yes.
Good evening, sir.
Yes. When, therefore, the head of state is informed prior to the sitting of Parliament what the true position is likely to be if the House should meet to do any business, then it begs the question, what is the best option for the head of state and also the incumbent government? Now,
When you say best option,
I am not a politician,
okay.
but I want to know if there are varying standards whereby a government of our country, under our democratic process, can be formed other than by a majority of the elected parliamentarians who sit in the parliament. An elected majority, as far as I am aware, is the only acceptable standard by which the government in our democracy can be formed, even if that majority is only one seat. The example of the government of Nevis speaks to that.
Well, a government is formed after an election. The Constitution speaks specifically to the powers of the Governor General, where he makes a determination of that. Section 52(7) says, if at any time between the holding of a general election of representatives and the first meeting of the National Assembly. That has long gone. The first meeting has gone. The only way then that a Prime Minister can be removed by the Governor General in a situation is on a vote of no confidence. Other than that, the Governor General, to say forming of a government, the government was formed in 2010 January.
Now, you are saying the only other way is
On a vote of no confidence. Correct.
But that vote of no confidence takes place not in Warner Park, not in a playfield, but in the Parliament.
Correct. You're quite correct.
Yes. And this is demonstrated by the elected parliamentarians taking their rightful place in the government benches of the Parliament.
Well, government and opposition. Correct.
So
You're correct so far.
If on the government benches there are more elected representatives before the vote of no confidence is taken, that speaks to what?
So you're saying you don't need to have the vote then? If it appears that there are people, you have to take the vote. You have to take the vote. You can't presume the vote has to be taken.
It is clear. If you have more people sitting on the opposition benches in Parliament before the vote of no confidence is taken, it is very clear.
But even if there's a crossing of the floor, there are not more persons sitting on the opposition benches. There are more elected members. But the House is not merely comprised of elected members.
Well, the question here is that we're not talking about orange and apples.
But sir, while I understand what you're saying, let me just ask a question. Isn't it possible that after the debate, at the time of voting, that persons on either side could vote on a different position to what that side is voting on? Isn't that possible?
The question of a debate is a guesswork, because in truth and in fact, once a side has the majority, it can take it to a different level. It can ask for something else other than the debate. It could ask to exchange places.
No. Where you see that in the Constitution?
I don't think our Constitution says that at all.
But this has happened in
where and when?
In where?
It happened in Anguilla at the swearing in of the first Parliament down there.
I don't know.
Where the opposition was without anyone, and after the leader of government business was not in compliance with the rest of the members, they moved in the opposition benches and left him alone on the government benches.
Correct.
And he was asked to notice that he doesn't any longer have a government.
And he decided to...
And so it had to...
dissolve the House.
Then the government was changed.
The government wasn't
No,
changed.
he dissolved the House
and they had elections.
And they had elections.
You're entitled to your own opinion, but you're not entitled to your own facts.
I mean, good sense should prevail rather than getting into saga and all sorts of things. Do the honorable thing and let's make St. Kitts a peaceful country.
Well, I'd like to ask a question, Corder, and I have to, because I'm a staunch supporter of what happened in 1993. Do you think in 1993 that Dr. Simmons should have done the decent thing when the people said we didn't want you and resign? Do you think he should have done the decent thing and resign?
No, I've heard this thing debated, but...
It's a simple question.
But listen to me.
You feel that Dr. Douglas should do the decent thing and resign. Maybe I'm minded to agree with you, but I'm asking you a straight question. Do you think that Dr. Simmons then should have done that?
Hello, listen to me. Dr. Kennedy Simmons, realizing what transpired when Parliament was convened, he bowed out.
2 years after.
No, he bowed out.
2 years after.
Okay, all right.
He bowed out.
Okay.
Thank you.
Thank you.
Okay, thank you very much. All right. Okay. Well, I mean, you know, I just had to, you know, that's one of the difficulties I have with political support, because I was listening. But let me not get into that yet. Let us. I think that you answered the other caller's question when you went to the same section.
Yes. Both dealt with.
Yes, both dealt with the same. Let's go back to the telephone. Good night, caller. You're on.
Good night.
Yes, good night.
I'd like to find out why was Patrice Elizabeth removed from being Attorney General? What happened to cause that crisis?
I don't know that there was a crisis. That's the Prime Minister has the power to determine how his cabinet should be formulated, and he made that determination.
All right, are you there, caller? Okay, she's gone. Well, he was not fired, and you, as you rightfully said. Oh, let's go back to your cell phone. Good night, caller. You're on.
Good evening again, Mr.
Yes, good evening to you, my friend.
May I ask you guys a question?
Sure, go ahead.
Good evening, sir.
Good evening.
Do you have the authority or the powers to vote and the vote of no confidence?
No, a nominated member cannot vote on a vote of no confidence.
Right. Does he have the right to vote and the budget?
Yes, he does. That is correct. He has
Right.
the voting rights remain the same.
Right. So days where the Prime Minister is playing games with people in St. Kitts. If he's so powerful and he's so sure, just forget the vote and no confidence, forget the budget and call an election and show the people who is criticizing him that the people of this country love him.
So the Prime Minister must be...
Then he won't have no vote and no confidence, because Timothy will lose his seat, Sam will lose his seat, John will lose his seat, Lindsey Grant won't win in no road, and he'll have the majority, and there will be no vote, no confidence.
So you're saying
You
every
understand
time
what
there's a criticism of the Prime Minister in that respect, questioning his legitimacy or his right to be the Prime Minister, we should hold an election?
No, what I'm saying, the country is going deeper and deeper and deeper in a crisis.
Well, I keep hearing people use that word. I don't know where this crisis exists, perhaps on the radio stations. But
I mean, people in this country suffering.
There have been about 3 groundbreakings in the last few months.
You could eat what you want, drink what you want, sleep when you want, how you want. But you know how many people in this country are suffering?
Caller, let me ask you a question. Was there a crisis in 1993?
No.
Well, there's no crisis now.
No, but listen, Mr. Hope. You speaking about 1993.
I like to go back there, because
but listen, I cannot call people near Mandela. But there was a group of people in this country who was against what Dr. Kennedy Simmons was doing for poor black people.
Oh, I see.
And they used the Labour Party as a tool.
Oh, I see. And who is being used as a tool now? Once you're going to get into the politics, I'm not going to bring the Attorney General. I will take you on.
No, but we are on the same topic.
Who is being used as a tool now?
The Labour Party.
Still? I thought it's the same people can benefit.
No.
Because you know that it's only one set of people that benefit election after election after election. It is those who have the means of influencing government.
Why are you going to say those kind of things?
Because it is true.
People wouldn't suffer like this under Dr. Kennedy Simmons' leadership.
Maybe you have a different experience. There are those who will tell you otherwise.
But Mr. Horse, you know that.
I don't know that.
I said it last week.
I have suffered under both.
A lot of people in this country.
I have suffered under both. I, Austin Edinborough, have suffered under both. And I could be honest. You know why I could be honest? Because I stand tall above the partisan bias. And I don't need it to make a point. That's why I can be honest.
What I'm saying, Mr. Host, and I keep asking everybody the same question.
Yes.
What has Dr. Kennedy Simmons done wrong in this country?
Tonight is not the night to get there. I don't want to sidetrack the. I don't want to sidetrack the Attorney General.
The Attorney General.
All right.
Here you go and you break the laws to bring in a man just to stay in power.
All right.
And the Attorney General, I will call him the Attorney General.
Yes.
The Attorney General.
You would call me. I was sworn back in again, you know.
He did not vote with his conscience.
Okay.
Well, I voted in accordance with the Constitution. The Constitution facilitated that there can be an increase in senators.
Because he grew up in the village, he know how ghetto people be.
All right, caller. The telephone is really going wild, so I'm going to have to ask you to take 2 minutes. Yes. I want to give other people an opportunity as well. Good night, caller. You're on. Hello. Let's go back over here. Good night, caller. You're on.
Yeah, good night.
Good night to you.
You're always saying that you fear and everything. I hear listening to you all the time. My thing is this.
No, I didn't say. I never said I'm fear.
You saying about 1993. I guess you say then.
No, I didn't.
Well, that's what you're trying to imply now.
No. I'm not trying to imply that it was right then. I said it was wrong then. I have also said.
So long can justify.
Let us get clear on my position. I have always said that I, Austin Edinborough, do not believe that any Prime Minister who does not command the majority of elected representative has a mandate to govern. That's my personal view.
Yeah, but
I am saying that if you support what happened in 1993, then you're bound to support what happens now. I didn't support it then. I'm not supporting it now. But I don't need partisanship to make my point.
Back to that.
Well, the difference.
You're trying to justify it by going back to that.
Oh, well, okay, that's your opinion.
By going back to that.
I guess you're not listening then. If you think I'm justifying, you're not listening.
Well,
all right.
I guess I'm not the only person who will be thinking that.
Okay.
Well, the determination on on whether he commands the support or not of the majority of elected members has to manifest itself on the vote of no confidence after debate.
Yes.
That hasn't transpired yet, so we're being a bit presumptuous, perhaps.
No, I'm not. I'm just saying.
Well, not you, not
that
you.
I had the view then, and I have the view now, and I will have that view in the future.
That's fair enough, Mr. Edinborough, if you have that view.
All right, thank you. Good night, caller. You're on. Hello, caller. Are you hearing me? We seem to be not getting that line properly. Well, caller, I'm trying to get to you. Let's go back to this one. Good night, caller. You're on.
Hey, Eddie.
Yes, my brother.
Boy, you got a handful tonight.
Well, I always have my handful. You know that.
Listen, I got a question for the honorable guy,
The Honorable Jason Hamilton. Jason Hamilton.
Mr. Hamilton.
Yes.
Mr. Hamilton.
Yes, good evening, sir.
You don't have a problem understanding the Constitution now, do you?
I would think I have a good working knowledge of it.
All right. So which means you knew that your appointment the first time was illegal, didn't you?
I didn't, because that had been done previously, and our interpretation wasn't the interpretation that the court had ultimately decided. The interpretation that we have always had on it is that the Constitution allows the government side to have 3 senators, one of whom is the Attorney General. So I didn't know it was, as you're claiming now. If I thought that, I wouldn't have taken the oath in that way.
Really? Well, how come you had to take the court to decide that? I mean...
Well, just like how you can go on somebody's land and you think is yours, and the person take your coat and you honestly believe is yours until the court say it ain't your land. There was a certain interpretation the government side had on the particular piece of part of the Constitution, and until it was taken to court and the court said otherwise, the government maintained that view. It was done in 2000, and I think it was 6, 7, when Dr. Merchant was appointed.
Man, I'm going to be pretty straight with you. I really don't.
I'm trying to be straight with you too.
You're telling me.
Well, caller, let me ask then: Do you believe that when Dr. Merchant was appointed Attorney General, that he was there illegally?
Who, me?
Yeah, I'm asking you.
I wasn't
Because you are the one who's
so
saying that the gentleman is appointed illegally.
Well, that I knew that I was being appointed illegally.
That he knows that. And, the precedence was there, and nobody ever challenged it until now. And the Constitution is a matter of interpretation, as we've been saying all night. And we have shown where one judge can interpret something to say something, and other judges just interpret it entirely different, because we're all human.
Something. Did you guys appeal the case yet?
It hasn't been appealed yet, but the legal team is doing the necessary work that an appeal will be filed. We have 42 days.
So long, man. I mean,
we have 42 days to file the appeal. 42 days. 42 days ain't gone yet.
Okay. I didn't...
You have a rush about something?
No.
Okay, well, why you ask me why we taking so long? We have 42 days.
I'm very patient.
Okay, good.
I hear all this hoopla surrounding y'all and all this kind of stuff, so I'm wondering if you really got the fortitude to stand up against all of it, so.
Well, I pray daily, so I hope so.
Yeah. Good luck. Have a great night.
You do the
all
same.
Right, thank you very much, and thank you very much for still listening to the program. While we go back to the telephone line. Good night, caller. You're on.
Yes, Mr. Edinborough.
Good night to you as well again.
Yes. May I have some understanding for the benefit of the listening audience? What is the significance of the letter to the Gigi by the leader of the opposition?
You would have to ask the leader of the opposition. You would have to ask the leader of the opposition that he wrote it.
No, but in this enlightened age, how can an Attorney General not know the significance of such a letter?
Well, obviously you tuned into the program late, but Mr. Edinborough and I went through an authority that has been flaunted around as to what that significance is, and I've explained that before. So if you would want me to go over that for your benefit from joining in late, I can do that for you.
I joined late, yes.
I figured so as well, because we explained that already.
Another thing, too, is we have had an Attorney General for the year.
Which year?
Since the new government was formed in 2010, we have had an Attorney General.
That is correct.
Was there a need for another Attorney General?
The Prime Minister has the right to determine how he wants to formulate his cabinet. If you want to take that right from him, perhaps you should run for Prime Minister.
I'm just trying to find out. Because usually when you have these sort of things, there is some justification why that one has to be displaced for another. And so...
You mean like when Michael Powell was fired? That kind of justification?
Beg pardon?
Like when Michael Powell was fired? That kind of justification you mean?
Oh, so you mean Patrick Nevis was fired?
No, I'm not saying that. I'm asking. You're saying about justification. I'm asking, when is justification required and when isn't it required?
Well, it's a question of teaching.
I don't understand what you mean. When you say teaching.
What is what?
Well, in all honesty, how could you think that the Honourable Patrice Nisbet was fired when the Honourable Patrice Nisbet is still a minister of the government and our Minister of Foreign Affairs to boot? How could anyone think that he was fired?
Having increased the ministerial portfolios that he controls as well. To me, that's a promotion, but some might see it otherwise.
It beats me how anyone could think that he's fired when he still sits in the cabinet of the government.
Well, I heard a member of Parliament speaking words to that effect.
But he's not a part of the government and he's not the Prime Minister, so he could say what he wants. Because only the Prime Minister can tell you why he made the change, because he is the leader of the government as Prime Minister and he made a choice to reshuffle or change his cabinet. And he brought in another Attorney General. That is his prerogative.
That is true. I agree. No, I am not bashing anybody, but,
And I'm trying not to do that either.
What I'm trying to say is simply this. All of this saga out there, I believe from the standpoint of we having intelligent people in our parliament, we should be able to settle these differences amicably and in good order. But this is not happening. That is the point I'm trying to bring across.
Well,
we need to get all of this saga out and come straight to the point of getting... Tell me something. Do we have the House properly constituted at this point in time, where we have a deputy speaker?
Because we don't have a deputy speaker. But
we did not have a deputy speaker going for quite some time.
Which constituency are you registered in?
And I am not sure we still have one.
No, I'm asking, which constituency are you registered in?
Well, that has nothing to do with...
Well, did you tell your representative that perhaps he should have voted for the senator's bill because we needed a deputy speaker?
But isn't it...
You ain't answered the question yet, though.
Be a priority?
Say that again?
Isn't it a priority?
That what?
That the House to be constitutionally operated, you must have a deputy speaker?
Well, the government was moving to increase the number of senators to facilitate the appointment of a deputy speaker.
But why has it taken so long? Because up until now, it still has not been done.
So you're saying perhaps that should be priority and we should do that before the vote of no confidence?
The Constitution has said that.
So you're saying it should be done before the vote of no confidence or after?
The House is transacted. You must have in place a speaker and a deputy speaker.
And that was done at the time when the House was
constituted.
Yeah, but for the next session of Parliament, it should have been done too. And for the other session of Parliament, it should have been done too.
The Constitution doesn't... the Constitution does not say...
The Constitution doesn't
The Constitution speaks to when the House is constituted. I keep saying there is a problem with our Constitution. And none of us want to tackle... But it is true the Constitution is weak.
So let me ask you this
question.
question.
Ambiguous.
Carla, let me ask you this question.
What all times mean?
So you would have, if you were in the House, you would have voted on the senator's bill to allow an extra senator to be the deputy speaker.
The House is not properly constituted, and the Constitution says a senator could be made the.
Carla, you ain't answered my question yet, though.
I would certainly go along with that.
So you would have voted. You would have voted in favor of the senator's bill then.
It is a requirement.
So you would have voted in favor of it.
but you voted for the Senator's bill, but you still have not had a deputy speaker.
Would you have voted for it? That's yes or no?
No, as long as a deputy speaker is supposed to be part of it, I would.
Oh, okay, I'm not understanding that answer, but okay.
Right, thank you.
You're welcome.
Well, you know, that we go back to, we got both telephones lighting up at the same time. Good night, caller. You're on.
Good evening, Mr. Oaks.
Yes, good evening to you again.
Let me ask you on the lawyer question.
No, you know how, you know, wait, caller, because you know how I stand with respect.
No, I said let me ask you. And
I have the Attorney General here.
let me ask you on the Attorney General a question.
Go ahead.
Can the Deputy Speaker of the House be appointed from somebody from the government side?
Can be appointed from any of the members of the House.
No. Okay, so that means why Dr. Denzil Douglas did not appointed the Deputy Speaker in the House from his side?
Well, why the unity persons who are talking for that didn't allow the Deputy Speaker to come from their side if they believe in unity?
No. I'm just asking a simple question.
I asking one too.
Since the opposition refused, why didn't he appoint somebody from his side?
Unity is not a convenient thing, you know.
Well, caller, in all honesty, if you're asking a question of Dr. Douglas, only Dr. Douglas could answer it. That's.
Only he.
I can't tell you why.
Yeah, but I could. But
is it possible? Is it possible that he could have done it? Yes. Why didn't he do it? I don't know.
No, but the answer is in the studio with you tonight. The Attorney General is in the studio with you tonight.
Okay.
That's why he did not appoint that system. Okay. He did not appoint a Deputy Speaker from his side because he know there's no way he would have get what he trying to pull work. So he did it the other way around.
Okay.
He was trying to force the opposition to appoint a Deputy Speaker.
As a part of a unity thing and being in the best interest of the country that people are touting. One would have thought that would have been a good thing and a magnanimous thing to do.
The unity thing was a trick up his sleeve.
Unity thing was a trick up Dr. Douglas' sleeve?
What set up?
Dr. Douglas ain't talking about unity thing.
I'm a little bit confused.
Yeah, I'm not confused.
No, what I'm asking you, you said yes. You said that he could have appointed one from his side.
Yes, he could have. Yes, he could have.
Right, so he could have do that and get over with and have a Deputy Speaker in the House.
So does the opposition.
Deputy Speaker in the House, because I don't really know. What is really the power?
While you're on that, did you realize that some time ago the leader of the opposition said that Dr. Douglas did speak to him prior?
Concerning that?
Yes, prior to bringing it to the House, that Dr. Douglas did speak to him and gave him the reason why he wanted it?
Yeah, okay.
Well, if the opposition felt that Dr. Douglas was calling a bluff or playing bluff, why didn't they call his bluff then and say, well, okay, you don't need the increase in senators bill because we will give you that? Why didn't they do that?
Yeah, but the gentleman who they was asking, was targeting to be the Deputy Speaker of the House, he stood up in Parliament and gave the reason why he cannot be the Deputy Speaker. Because
so he didn't believe in unity for the country then?
Of the House. No. The Speaker of the House supposed to be a fair and balanced person.
And there's nothing to believe that the Speaker isn't fair and balanced.
So therefore, I think it's unfair to say that Dr. Douglas...
If the Speaker of the House was fair and balanced, we want to be running around the bush because he tell the Prime Minister, listen, there is 6 people over there against you, and there's 4 over here for you, or 5. So please just bring the vote and the confidence forward. So that's the way I'm saying it.
All right.
The gentleman explained to you, he don't think it's fair for him to be the Deputy Speaker because he already on that side of the bench.
So therefore, how
the Deputy Speaker can come from the opposition side? What are you saying then? I don't understand what you're saying. The Deputy Speaker, as Patrice was Deputy Speaker, forgive me, the Honorable Patrice Nisbet.
All I am simply saying, the gentleman made it clear that he don't think he could execute his duty fair and balanced when he's on that side.
All right.
Fair enough.
All right.
I just figuring that the Speaker of the House should be a neutral person down the line. Whether he have political side or whatever, that should be his personal
in recognizing that there should have been a deputy speaker, you would have voted for the increase in senators' bill then?
Once he was going on for the country, I want to do it.
So you don't think that they needed a deputy speaker then?
Once it's going to harm for the country, and I wouldn't do it.
So you are saying, from the start you said that the deputy speaker is essential. But now you're saying you wouldn't have voted for the bill to facilitate that? I'm not understanding, Carlo.
You did not hear me say nothing like that.
Because I realize you ain't answering me no more.
But I asking you why he didn't appoint one from his side.
Because all of the government persons on the government side.
In all honesty,
I can't answer that, no?
Honorable Attorney
Yeah,
General,
that would be speculation. That's correct.
That's speculation, and he's not asking for speculation.
It's just a simple
No, if you want the Attorney General opinion on it, then ask that. But if you're going to ask him, you can't ask him why Dr. Douglas did or didn't do something. He can't answer that.
But he did the same thing to me. I made it clear on my side of view that the gentleman stood up in Parliament and gave
No.
the reason why.
We didn't move off of that. I was asking you if you would have voted for the bill or not, and you sidestepped that. I wasn't asking about his explanation at all again.
No. I said if it's good for the country, yes. If it's bad for the country, no.
So
I give you my answer.
when the bill was being debated the other day, if you were in the House, what would you have voted?
You mean when the Deputy Prime Minister...
The other day, the same day you talk about with the rigmarole. How you forget that so quick, man?
Man, forget it, but I just...
What would you have voted for the bill or against the bill?
I'd have voted against the bill.
So you don't think we should have had a deputy speaker then?
Well, all right, Carl. I mean,
Not with 4 against 6.
I'm not running you, but you know.
No, yeah, let somebody else
Yes,
have a
give somebody else a turn.
Bye.
All right, thank you. Good night, caller. You're on.
Good night. I got a lot about listening to you.
Okay.
You got a lot about listening to you.
Thank you.
Good night, caller. You're on.
Yes, good evening. I would like to answer the question. The caller just got out the phone a while ago.
You would like to answer? Did he ask you a question? Caller, if you hear me, caller. I have a way of dealing with my program. You can't answer a caller who asks a question of Dr. Douglas. You are not Dr. Douglas. You can't answer it.
No, I ain't disrespecting your program.
No, I'm just saying that you can't answer for Dr. Douglas because you are not Dr. Douglas.
No, I'm answering for him,
Oh, okay. Go ahead.
I was telling you that which he wants the edge to answer the question, right?
Okay.
So I put it the way, what you're trying to say, okay.
Mm-hmm.
The bill come to the House, which is, as he said, the bill they go to the courts.
Uh-huh.
If it didn't go to the courts, the bill he'd appoint the deputy when he wanted, and he signed. So the House would be in order. So that's it. That's what he really wants. That's what he wants.
But interestingly, that matter has never been tested in court, and it has been so since the start of this Parliament.
Well, they've conveniently somebody might challenge it.
No, what he's saying. Which is, he said the matter with the cat to the court, which is with the opposition cat to the court. If the matter didn't went that way, then he and the government said he'd appoint deputy speaker.
Definitely, that was one of the purposes of the bill.
Well, according to him, that was the main purpose of the bill.
That was the main purpose.
The speaker that appoint on the government side. That's what he was saying.
That is correct.
Okay. All right, caller. Thank you for giving us your understanding. And we go back to the telephone line. Good night, caller. You're on.
Good night.
Yes, could you turn the radio down, please?
I would like to find out what length of time would the Attorney General say is reasonable?
For what?
To bring the motion of no confidence.
That's a matter for the Speaker. The Speaker determines that. The Clerk of the House, actually. So the Clerk has the agenda of the House and what has been put before, and that determination will be made by the persons in that department.
Okay. Good night. Okay, all right. We've lost that one as well. All right. We are, it has been going ever since we opened up the line. Good night, caller. You're on.
Good night, gentlemen.
Good night to you.
Well, I don't understand why some of your callers understood the Constitution so well in 1980, but find it so difficult to understand it
Well,
Now in 2013, I mean, what happened to the memory? They don't remember. They understood.
well, it's called convenience.
Convenience. I was just about to say the same thing.
So I don't understand why they find it so difficult to understand in 2013. Same constitution back in the 1980s.
Well, it came into being in 1983. It's the same constitution that we have, and I've always said that the framers of that constitution knew very well what they were writing, and all of the loopholes, in my opinion, that is in there, and all of the ambiguity is because they felt that at some point they would need them. I think it's about time that we begin to seriously consider constitutional reform. Let's take this call. Okay, we are getting to the end of the program. We've got the last 4 minutes. I've borrowed enough time from Ruckus already. So if you're going to call in, we have 2 more minutes for calls before we ask the Attorney General to wrap it up for tonight. So anybody who calls in 2 minutes will hear you. If you don't call in 2 minutes, unfortunately, we will not be able to accommodate you tonight. But I'm hoping that this kind of... Good night, caller. You're our last caller for tonight.
Yeah. I was just wondering, what is in the budget that they're so afraid to hear?
I don't know. I don't have an idea what the budget will hold.
Well, we just listen out for the budget when it comes. It will be a budget that would try to bring relief to people. We are on the economic
Good night,
recovery
caller.
path, so.
I did promise that would be the last, but you will definitely be the last.
Okay. Thank you for having me tonight. How are you? I'd just like to say congrats to Jason Hamilton. He's a fellow villager, and I think that he's doing an extraordinary job. He's a youth, and you have to encourage young people like this. I think Junie right now is having a youth program for young people that are making strides in the communities and the communities around. So it's very positive to have a young person from my constituency, which is constituency number 3, doing such a good job. And I think that he handled himself very well. And the Prime Minister who has employed him should be very proud that he has done him very proudly. And so I just want to commend him for being on your show tonight. And we look forward from his constituency for what he has to do in the future. So once again, thank you, Mr. Hamilton. Thank you, Sir Moderator, for having him. And I'd like to say from his home base that we encourage him and we support him. Have a wonderful evening, both of you.
Thank you, Carl.
Well, thank you very much, and I hope somebody don't think that I knew what this call was going to be about. I just decided, you know something, let me take this for the last call. Well, I'm going to give you the last word, Jason. So my last word will include a political question that I must ask you, and I purposely didn't ask it within the interview before because I did not want it to sidetrack the discussion on the Constitution. But before I ask you the question, let me say that it was a pleasure having you here. And I think that these kinds of discussions can only go down to the benefit of the society as a whole. And I know that more discussions such as this will be coming our way, not only from Freedom FM, but as we seek to educate and mature in our ways of looking at things.
Well, thank you for having me, Mr.
Well, the question is, it is being said that you are most likely going to be, or you are already, the Labour's candidate for constituency number 3. So I'm going to ask the political question. It has been said. Is it a fact?
Well, a determination hasn't been made on that matter yet, but it is my intention to be the candidate for the Labour Party in West Basti in the next election. There's a process that the party has in place where the branch submits a short list of names to the National Executive, and that is then sent on to another committee where the recommendations are made, and that is my hope. But I will be guided by the people. If the people want me to serve, I'm always willing to serve in any capacity that they give me. They ask me to do that in.
All right. Well, thank you very much. And it was a pleasure. And to the rest of, to my audience, you know I love you. We may not always agree, but that makes healthy discussion. Good night, and I'll see you again, well, in the next 2 weeks. Next week, Wednesday, the youths will be here with Think About It.